Hello, and welcome to Hofstra Law School's Video Viewpoints series. I'm Kristen McMahon. With me today is Professor James Sample, who recently co-authored a report titled The New Politics of Judicial Elections. Can you talk a bit about the main findings of the report?
The report documents the dramatic increase in campaign contributions and campaign expenditures, often by major stakeholders before our judicial systems, before state courts, in support or in contribution to candidates for judicial office. And what the report finds is that there's been an exponential increase in the volume of money over just the last decade alone. The scope of the increase is really such that the difference is not merely one of degree, but really a difference in kind. Judicial elections, which used to be relatively sleepy, low salience affairs, have turned into a high stakes battle pitting interest group versus interest group, pitting business versus business, trial lawyers versus big business, conservatives versus liberals, but also really the moneyed interests across the ideological spectrum against average citizens who really want just a fair day in court.
And exactly how much is an increase in the past decade?
So from 2000 to 2009, over $206 million was spent in just direct contributions alone, a figure that's 2.5 times the total of the prior decade. And that figure is misleadingly low in itself because it doesn't take into account massive independent expenditure campaigns, which are really becoming, in many respects, the way the battle is fought financially in our campaign system these days. The sum totals of the money are extraordinary. The sum totals in individual races with high stakes and stakeholders being the prime funders of those campaigns is really such a commonplace problem now that it's really become pervasive to the degree where Americans are questioning the courts in their states.
And how does this funding impact our legal system?
Well, the perception of 3 out of 4 American citizens is that judicial campaign contributions are influencing the core of the judicial process, the judicial decision itself. What's scarier, in my view, is that in a written survey of over 2,000 state court judges around the country, nearly half of the judges themselves agree with that sentiment. Now, psychology being what it is, the judges naturally think it's all their colleagues who are being influenced and not themselves, but social science is rich with studies that show that in all sorts of contexts, human beings are actually really, really bad at estimating their own biases. And so when half of the state court judges themselves think the influence is a problem, and when 3 out of 4 Americans believe it's a problem, and when we can't prove, and this is one of the real problems and one of the reasons I think we need to address the concerns systemically, you can't prove, except in the rarest of cases, that there was an actual quid pro quo. And if you can prove that, then you have a case involving criminal bribery and the judge will go to prison. But that is the rarest of exceptions. And in the normal course, it's actually the everyday scenario where just because you can't prove causation, the correlation is such at such a high level that at least in certain instances, there is not just the perception, but there's the actuality of pay-to-play justice.
What are some of the key cases where these correlations can be made?
Well, the best example in recent memory is a case that I had the privilege of working on called Caperton versus Massey, a case that went up to the U.S. Supreme Court, involved a West Virginia Supreme Court justice who was elected with the benefit of $3 million in independent expenditure support. A sum, $3 million is a lot of money by any measure and in virtually any context, but it put it in perspective in the context of this particular campaign. $3 million represented more than the sum of all of the other expenditures in that candidate's support combined. All of these expenditures took place while the CEO of a mining company, the individual who spent the $3 million, had a $50 million appeal pending before the West Virginia Supreme Court. The judge then cast an outcome determinative vote in favor of his supporter, and the U.S. Supreme Court found that that was a violation of due process for that judge not to disqualify himself from the case. That, however, is an extreme and isolated instance that reflects a much more pervasive problem, and U.S. Supreme Court review is not going to be available in the everyday case. It's probably not even going to be available in exceptional cases over the long term. So it's my view that states need to be proactive and address these concerns systemically with programs like public financing, so that judges are not beholden to campaign supporters and financial supporters. Rigorous recusal rules that force individuals like the justice in West Virginia to recuse themselves based on an objective appearance of the impropriety of the problem.
And do you anticipate that spending will only continue to increase unless these measures are enacted?
I think spending will increase unless these measures are enacted, both because the trends, it's hard to put the genie back in the bottle, and because recent Supreme Court cases, the Citizens United case, which has received a lot of press, involving corporate and union general treasury funding of congressional and presidential campaigns at the federal level, has also invalidated similar prohibitions on corporate general treasury funds and union general treasury funds in state races. So the biggest adversaries, as a general matter, in state judicial races are the plaintiffs' bar and the business interests on the other side. Well, given that, and given that the pool of funds from which they're now able to draw is exponentially greater than it was prior to the Citizens United decision, it will be simple cost-benefit analysis. If you are a company facing, let's say, a $300 million case, and you think that you can spend a mere $3 or $4 million to influence or choose a judge who will hear your case or who will hear an appeal of your case, or if you're on the other side, same token, the stakes are so high that it'll be simple cost-benefit analysis for individual major stakeholders before the courts, whereas the average citizen, for whom the courts are supposed to represent the ultimate promise in our system of equals under the law, the cost-benefit analysis of spending even a minimal amount on a state court race is abysmal for the average citizen, who has a serious stake in a proper judiciary and in a fair judiciary, even though they may never set foot in a courtroom themselves.
Is spending in judicial elections a partisan issue?
Concern over the influence of green is not and should not be a matter of red versus blue. Many issues in this country, seemingly now, we're almost hardwired to see the issues and the debates in our society, politically and even among citizens, as though everything is a matter of left versus right, as though everything is a matter of conservatives versus liberals, and a strict binary proposition. You're either with us or against us. But when 76% of Americans are concerned about the influence of campaign contributions in the courts, this is an exception to that rule. The concern crosses partisan lines, it crosses ideological lines. Oftentimes, even the general adversaries in these disputes are, you'll end up with a business-to-business dispute where one business or one individual associated with a business is a major supporter and another business is not. Nobody wants to go into a courtroom and know that their adversary spent millions of dollars supporting the judge who will decide their case. That's about as fundamental a belief as there is, and it's really a question of whether we're going to follow through on the fundamental American promise of the right to an impartial hearing before an impartial arbiter, where we enter as equals under law.
Well, thank you very much for your time. For more information about Hofstra Law School, visit law.hofstra.edu.